Hello, everyone, and welcome to Uncivil Law. I hope you are having a wonderful day today. And for our case today, we are discussing a case from the United States Court of Appeals for the Sixth Circuit in the case of Christopher Lee Murray Bay versus the Charter Township of Canton, Ohio. In this case, Christopher Lee was followed because he was black and he was traveling in a beat-up car at night, and the cops thought that was suspicious for some reason. He went about doing normal things like going to Walmart and buying space heaters, and standing in line and paying for them, and somehow the police still found this suspicious, and then they tried to arrest him for stuff and things. So, the United States Court of Appeals for the Sixth Circuit is reviewing this and determining whether or not the officers of the Charter Township of Canton, Ohio were violating his civil rights in this stop. So, we're going to read about this and what happened, and let's get started with this. Uncivil says there better be a lot of grade A cases full of lots of misbehavior. Is cop pursuing black guy because racism enough misbehavior for you? Or do you want to start immediately with the cop ripping a guy's shoulder out to the point it was audible and not getting medical attention? Which one of those is more shocking for you? You thought the racism was the worst of it. No. It gets worse as we go on. But let's just stick with the racism case. Then we'll get on to the blatant, brutal physical assault case. The law is not always pretty, my friend. The law is not always pretty. Christopher Lee Murray Bay filed a lawsuit under 42 U.S.C. 1983, alleging that several police officers stopped him without reasonable suspicion of criminal activity in violation of the Fourth Amendment, and they investigated and ultimately stopped him because of his race in violation of the 14th Amendment. The officers moved for summary judgment based on qualified immunity. The court below denied the motion. We dismiss in part, affirm in part, reverse in part, and remand. So basically, all the options. At approximately 2:30 a.m. on March the 16th, 2013, Bay and two friends went out in Bay's minivan to purchase space heaters for their apartment. Bay had purchased the older minivan just a few days before, so it had a temporary registration tag, but no license plate. The three first went to a Mayer store in Lenova, Michigan, a western suburb of Detroit, but came away empty-handed. So they drove across the street and sat in a parking lot of a closed Lenova Walmart while they tried to locate a nearby store that would be open at that time of night. They then drove to a Walmart in neighboring Canton, Ohio, where they found and purchased the space heaters they wanted. Just as they were about to drive home, they were surrounded and stopped by Canton police officers. Unbeknownst to Bay and his friends, while en route to Lenova Mayer, the minivan they were driving had caught the eye of an undercover Lenova police officer, Sergeant Andrew McKinley. McKinley led an undercover team of Lenova police officers called the Special Operations Unit, which conducted surveillance in the interest of crime prevention. Lenova had recently experienced an unusual number of break-ins at cell phone stores, so the officers on duty that night, McKinley, Megan McAlter, and Eric Anibis, each driving a separate unmarked vehicle, were paying particular attention to potential retail crimes. When Sergeant McKinley observed Bay's beat-up minivan at an early morning hour, he started to follow it on a hunch. According to his training and experience, criminals often use stolen, older vehicles for retail crimes, so police cannot trace the vehicles back to them. At some point before Bay and his friends entered the Mayer store, the officers noted that the minivan's passengers were black. Well, that's just super duper suspicious right there, right? Black people traveling in a minivan trying to purchase things at stores. Well, that just totally makes it rational, right? The officers continued to follow Bay's minivan from a distance as it drove from the Lenova Mayer to the Lenova Walmart parking lot and finally onto Canton Walmart. At one point, the minivan got onto a northbound freeway, took the first exit, and then immediately re-entered the southbound freeway. To the officers, this resembled a cleaning move, a tactic used to draw out or shake officers who might be following. Or, in the alternative, it means they missed their exit, which I have done many, many times, and therefore have had to enter and then immediately exit to get back to where I'm trying to go. When the minivan arrived at the Canton Walmart and its occupants, Bay and his friends, entered the store, Officer McGeeter followed them in on foot at McKinley's direction to observe them. She passed information to McKinley via cell phone as she followed them through various areas inside Walmart, and McKinley then passed some of that information along to the rest of the team via the radio. We've now got an entire team of officers watching a bunch of black men shop in a Walmart. That's just super great. McAtter told McKinley that she watched the young men separate, with one of them going into the hunting section and looking at guns. The three of them proceeded to the electronic sections, where McGeeter saw nothing unusual, though at one point she may have relayed that she thought the three were contemplating a push-out. She never saw the three leave or attempt to leave the Walmart without paying for the merchandise in the shopping cart. Shopping and attempting to purchase things. Totally suspicious. To the contrary, she relayed to McKinley that Bay and his friends stood in line at the cash register, flipped through some credit cards, and paid for the items in the shopping cart using the card, as normal people do at stores. Falk waited outside Walmart for fewer than 6 minutes before McKinley notified Falk that Bay and his friends had exited the store and directed to stop them. Falk and the other Canton police officers surrounded the van and ordered him out of the vehicle. Since Bay was carrying a concealed weapon, he properly notified Falk that he was armed and pointed to his holster so Falk could remove the weapon. Bay also produced a concealed weapons license. Falk asked to see Bay's receipts for the space heaters, which showed no signs of fraud. However, Falk discovered that Bay's concealed weapons license had expired and so arrested him. Bay was charged in Michigan State Court with a felony offense of unlawfully carrying a concealed weapon. Unlawful due to the expiration. However, I suspect, if his race may have been different, that perhaps this charge may not have been brought. For unknown reasons, the county prosecutor presented only Falk's testimony and not McKinley's at the suppression hearing, even though Falk had stopped Bay at McKinley's direction. Falk truthfully testified he personally had seen no suspicious activity. The state court found the stop unconstitutional and suppressed the evidence, and the case was dismissed with prejudice. Yeah, this makes no sense to me or the court, right? You want the stop to be lawful. In order for the stop to be lawful, you have to have some kind of suspicion, bare minimum, right? Reasonable articulable suspicion, bare minimum. So, the officer who did the stop can rely on what he heard, but he didn't see anything. So you asked him, well, did you see anything? No, I didn't see anything suspicious. Maybe you should have called the other officer to the stand and say what he saw so that you could build a case for some sort of reasonability. But you didn't do that. You just called the officer who actually made the stop, not the one who caused the stop to happen. And so you have an incomplete record. And so as a result, the court looks like, well, there's no suspicion here because the prosecutor done screwed this up. Okay, that's just weird. Bay then filed his civil rights action against McKinley, Ebis, McAlter, and Falk, alleging violations of his Fourth Amendment and equal protection rights. The officers moved for summary judgment based on qualified immunity. The district court denied that motion, as well as the officers' subsequent reconsideration motions, and the officers timely appealed. We first addressed the Fourth Amendment claim arising out of the alleged unlawful stop. For reasons that follow, we conclude that McAtter, Ebens, and Falk are entitled to qualified immunity against the claims. The claim against McKinley, however, must go to a jury. So we see here that the court, as it should, is considering the liability for each of the officers individually. And as the court is going to get to in more detail, under 1983, in order to find violation of civil rights, you need to find that each person who's involved has violated your civil rights. So some officers, based on what they knew, didn't violate rights because they didn't know anything that would cause them to be violation. However, the officer who basically initiated all this knew the critical information. As a result, he's liable because he knew well that the stop shouldn't occur. So the officers can rely on their fellow officers. The person who started it all can rely on nothing because he's either a moron or just completely discriminating. McKinley argues that he's entitled to qualified immunity because he had reasonable suspicion of criminal activity in order to do the stop. We have said the Fourth Amendment divides police-citizen interactions into 3 tiers, which must be justified by correspondingly increased levels of suspicion. The consensual encounter, which may be initiated without any objective level of suspicion. the investigative detention, which, if non-consensual, must be supported by reasonable articulable suspicion of criminal activity, and the arrest, valid if only supported by probable cause. Considering the facts in the light most favorable to Bay, what happened was a non-consensual investigative detention, and so there must be reasonable suspicion for the stop. So again, I'm brought back to our discussion from the Supreme Court case of Kansas v. Glover. Reasonable, articulable suspicion would be nice. Individualized to the circumstance would be nice. Yes. Reasonable suspicion exists when, based on a totality of the circumstances, a police officer has a particularized and objective basis for suspecting the particular person stopped of criminal activity. This standard requires more than a mere hunch, but at the same time it's satisfied by a likelihood of criminal activity less than probable cause and far less than preponderance of the evidence. In considering all the circumstances, the question is not whether there is a possible innocent explanation for each of these factors, but whether all of them taken together give rise to reasonable suspicion that criminal activity may be afoot. So the court here is pointing out that reasonable articulable suspicion can be based on a bunch of things which, if considered together, might be explained away by innocent explanations, but in their totality are suspicious because they're put together in some sort of unusual way or unusual combination. So they're saying, look, if every one of these things individually may be totally innocent, but in some combination, maybe there's something you can articulate that makes it, hey, there's something suspicious going on. And basically the best case on point about this probably is the case that started it all when it came to reasonable articulable suspicion, Terry versus Ohio. In that case, the police officer looked at a person because during night, among other things, he passed by a store window 3 times. Now, obviously, that in and of itself isn't illegal, but taken together with other things, he thought he was casing the place, which it turned out he was, and he searched him for stuff which he had on him. And so that's an example. You know, there's nothing illegal about it per se, but taken together with other things, 3 times at night, looking in the window each time, maybe he's casing the joint. That might be something that will qualify as reasonable articulable suspicion. And again, it's much less than probable cause, so we're not looking for more likely than not. We're looking for something much, much less than that. Probably like a 1 out of 10. So just basically, is there enough to give an officer the basis to investigate further? That's kind of what we're looking for. Taking the versions of the events most favorable to Bay, McKinley violated Bay's Fourth Amendment rights by directing a stop without reasonable suspicion. When McKinley directed Falk to initiate the stop, he knew only that 3 young men had driven an old minivan to 3 different stores in the early morning, at one time reversing direction on the highway. McAtter had followed them around the 3rd store and had not observed any criminal or even suspicious behavior. In fact, she had watched them stand in line at the cash register, flip through some credit cards, and pay for the items with the card. And she had relayed this information to McKinley. There was simply nothing here to give a reasonable officer in McKinley's shoes the impression that criminal activity may be afoot such that an investigative stop would have been constitutionally reasonable. Matt Arnold says, can you comment on where you think qualified immunity should be revisited? Yes, I do think it should be revisited. I don't know if it should be so far as like taken away completely. Because, you know, the ultimate like problem that this is trying to ultimately solve, right? The ultimate problem this is trying to solve is, you know, an officer has to make a life or death split-second decision, like to use force, to use a gun, for example. And you know, he may very well be mistaken, in fact, but the circumstances are such that, you know, and we can't necessarily like delineate all those examples in advance, right? We can give some examples of like where we would be okay with the officer doing this, but we can't really delineate them all in advance. And so the idea is like, we're going to create a standard that gives some flexibility here because we, whether we're jurors, citizens, lawyers, judges, we have the benefit of lots of time in hindsight, right? We have the benefit of, as it were, watching the tape in slow-mo many, many, many times, whether it's literal tape or not, it's a metaphor. Whereas the officer is watching it in real time for the first time. And so the idea is that they may make mistakes that are reasonable in the moment that would look to us unreasonable in retrospect. And we can't Monday morning quarterback this thing. We're not there in the moment with the decision that we have to make in a tenth of a second, when lives are on the line. So that's the problem. That's the real problem we're trying to solve ultimately. But as we have discussed many, many times, the 1983 case law has gone kind of off the rails. It's basically been something where it's like the underlying thing we're trying to fix, and then one exception more, and one exception more, and one exception more, and one exception more. This is incidentally why I've said on the stream before that, like, when it comes to common law, you can't say, let's just make an exception this one time, because it doesn't work that way. Everything builds on top of everything else, and it has a tough time of stopping in a particular place. So the slippery slope is less a fallacy in law than it normally would be in most other contexts, because things have a tendency of doing that quite frequently. And that's kind of what happened here, in my view, is it kind of got out of control, got out of hand. Which, incidentally, is a perfectly reasonable basis for the Supreme Court to review, if you take O'Connor's opinion from Planned Parenthood versus Casey. She wrote an opinion about 4 reasons why you might want to review, and like changes in facts or changes in workability are examples. And so this would be an example of where, we put in practice and it's been a problem, and then we got to fix it again. So, like, I don't know whether or not we should figure out some way of constraining it more or killing it altogether. But yes, either way, I think it needs to be reevaluated, because I think it has gotten to the point where it is causing more problems than the underlying problem it was trying to solve. And so we need to figure out a way to solve the underlying problem without creating more problems in the solution. So yes, I think it should be reevaluated. True, we must allow officers to draw on their own experience and specialized training to make inferences from and deductions about cumulative information available to them that might well elude an untrained person. And McKinley presents several reasons why some of Bay's actions could have been consistent with more devious motives. For example, McKinley testified that criminals frequently use stolen old vehicles that cannot be traced to them if they flee the scene, and points to his testimony that paper registrations on a van window did not appear in a record search. He likewise contends that Bay's reversal on the interstate was consistent with the cleaning maneuver, but even taken together, these meager observations are not enough to constitute reasonable suspicion. Lastly, McKinley argues that he could have lawfully stopped Bay independent of the retail fraud investigation. The temporary tag number did not appear in the state database, and so, McKinley says, he had probable cause to stop Bay for driving an unregistered vehicle. It is true that an officer's subjective motivations for initiating a stop are irrelevant to the existence of probable cause, or in this case, reasonable suspicion. So as long as there were facts known to McKinley that objectively constitute probable cause of a civil infraction or reasonable stop of a criminal offense, the stop would not violate the Fourth Amendment. So what the court just basically said there is that when looking at whether an officer is conducting a stop lawfully, we don't look or even ask about his actual motives. We don't look to his subjective motives. We look to it objectively, and we ask questions like, would a reasonable officer be able to find any grounds, even other than the ones the officer apparently did, any grounds for which they could have conducted this interaction? So even if the police's real motivation in their heart of hearts is based on discrimination, if the person has a broken taillight, the court says, well, they had a broken taillight, so we're not even going to bother asking whether or not they had any other motivation. And so that's kind of the thing they're talking about here. It's an objective test that just looks to whether an officer had some reason to do it. So for better or worse, I'm not defending it, I'm explaining it. For better or worse, that is the standard that is used. So that's what they're talking about. I feel like I have an increasing need sometimes to say, I'm not defending it, I'm explaining it. Because sometimes I feel like I'm going to get, I feel like someday, and probably sooner rather than later, I feel like someday I'm going to get whacked over the head for being a horrible, horrible person for just merely explaining what the law is. Because I explained something and it's like, well, that's racist. I'm like, but I'm just explaining what it is. I didn't invent it. I'm telling you the reality. So I feel like I have to increasingly say a disclaimer, which is kind of annoying to me. I'd rather not do the disclaimer thing and just be understood, but someday someone's going to misunderstand me, and probably soon. But viewing the record in Bay's favor, there's a genuine issue of material fact on whether there was evidence from which a reasonable officer could justifiably believe Bay's van was unregistered. On the one hand, McKinley testified that one of the officers, though he wasn't sure who, had asked the dispatcher to run a temporary license plate and had come back no record. On the other hand, McKinley affirmatively testified that Bay hadn't done anything wrong and he'd absolutely not committed any crimes in Lenova. And Bay pointed out, besides these conflicting statements, there's nothing else in the record, like a search printout or a recording of the call to dispatch, for example, to directly indicate that any registration search came up empty-handed. Eniblis recalled the license plate situation a little differently as well. He testified McKinley had told the other officers the problem was that the license plate was not readable. Taking evidence in the light most favorable to Bay, a material question of fact remains, and it'd be inappropriate to resolve this issue on summary judgment. So it remains an open question, according to the Court of Appeals, whether or not the officer had a basis to pull it over because of a potentially invalid tag. The officer says he ran a search and he couldn't find one, but there's evidence to the contrary. And so that's something a jury will have to figure out in terms of ultimate liability. What in fact happened? Did the officer in fact do a search and came back, or did that not occur? And so a jury will have to evaluate that and render a decision. On the other hand, MacArthur and Eniblis are entitled to summary judgment because Bay has not shown that they personally participated in actions that violated his Fourth Amendment rights. Bay's Fourth Amendment arguments constantly lump the officers together, but to establish liability against an individual defendant acting under color of state law, a plaintiff must show the defendant was personally involved in unlawful conduct. So, as the court is pointing out here, 1983 is individualized for each officer. In each officer, you have to prove the constitutional violation, and you don't do imputed liability. So the issue is as to each of them individually and what they knew and what they didn't know, and you have to show that individually rather than as a group. We conclude that Falk, the Canton uniform officer who executed McKinley's direction to stop Bay, is entitled to qualified immunity. The collective knowledge doctrine permits an officer to conduct a stop based on information obtained from fellow officers. But what do we make of the fact that the collective knowledge doctrine here did not amount to reasonable suspicion? In such circumstances, the Supreme Court has recognized the availability of a good faith defense for an officer who relies on erroneous collective knowledge of others to make a stop. We have said the officer is not subjected to liability if he, through no improper action or inaction on his part, conducts a stop that's unconstitutional due to the error of a generally trustworthy source. So that is the end of the case of Christopher Lee Murray Bay versus the Charter Township of Canton, Ohio. In this case, we learned that Christopher Lee and his friends were going about normal business trying to buy space heaters from stores at 2:30 in the morning, which, is not illegal. And they went to the store and bought the space heaters with money and were behaving completely lawfully. But they were stopped by the police anyway. And now they're suing for violation of their civil rights. We learned that the original officer who caused the stop to occur may be held liable for his violations because he knew that nothing was suspicious based on the evidence he had. However, his fellow officers relied on him because they didn't know the full story, and so they're not liable because they simply trusted a fellow officer to tell them the truth. But they weren't. So the original officer who instigated this is liable. His other officers are not liable. And we will see what happens next, and that is the end of this.